I will resume with the matter of Masuta versus State Security Agency, report number 24 of 2022-2023. The PPSA investigated allegations that the State Security Agency unduly delayed paying the Africa Alternative Institute, AAI, 14,264,684 rand and 42 cents, excluding interest accrued on the areas for services rendered from May 2018 to March 2019. Dr. Mukobe Masuta's complaint dated 30 October 2020 gave rise to this investigation. The AAI is his company which allegedly rendered services in connection with the verification of students from the universities of Johannesburg, Venda, Free State, and KwaZulu-Natal during the period referred to above. According to Dr. Masuta, the AAI entered into an agreement with the SSA during the financial years 2016-2017, 2017-2018, as well as 2018-2019, to implement a project aimed to providing intelligence. Intelligence in this regard referred to information that meets the stated and understood needs of policymakers, which the AAI collected, processed, and narrowed to meet those needs, to reduce uncertainty, and to provide the SSA with decision-making advantage. With the AA's deliverables defined in the agreement, the SSA was allegedly responsible for paying for services rendered on a monthly basis, based on a jointly designed and costed implementation plan. The project was allegedly approved for the financial years 2016-2017, 2017-2018, and 2018-2019, and ran fairly well until May 2018, with both parties implementing and honoring their ends of the agreement. For the 2018-2019 financial year, the AAI was allegedly paid in March, April, May in 2018. After May 2018, the AAI allegedly started experiencing a breach of the agreement when the SSA failed to honor its payment at the time. The AAI allegedly continued to work around the clock to meet all the deliverables at its own cost, to ensure that the production of services are met as per the agreement with the SSA. Dr. Masuta indicated that the matter remains unresolved despite numerous steps he took in an attempt to find resolution. Following a thorough analysis of the complaint, Public Protector South Africa decided to focus the investigation on whether the SSA unduly delayed to pay the AAI the 14 million rand owed to them, by them rather, excluding interest accrued on the areas for services rendered from May 2018 to March 2019, and if so, whether this amounted to improper conduct as contemplated in the Constitution and maladministrated and or undue delay as contemplated in the Public Protector Act. Having heard and received evidence from both parties and applied the relevant law, Public Protector South Africa is of the view that it would be injudicious to continue with this investigation. We take this view on the ground that a dispute involving the validity or legality of the contract, as revealed by evidence, a claim for money compensation, as requested by Dr. Masuta in this matter, may best be settled by the court of law, as previously decided in the GEMS matter, which was investigated by this institution and that was successfully set aside on judicial review. Moreover, the SSA has referred this matter to the Investigating Directorate of the National Prosecuting Authority for Criminal Investigation. As a result, the PPSA will not engage in a parallel investigation in a matter which is a subject of an ongoing criminal investigation by other competent authority. This is necessary to avoid duplication and the possibility of misaligned findings between the PPSA and other state institutions. I move over to the matter of Shivambu versus Godan, report number 25 of 2022-2023. The PPSA investigated allegations of a breach of the Executive Code of Ethics by the Minister of Public Enterprises, Mr. Pravin Godan MP, in that he irregularly appointed Ms. Tariseng Buroto as Chief of Staff despite prima facie evidence that she does not possess the minimum requirements for the post. In addition, it was alleged that the minister irregularly appointed Abacus Financial Crime Advisory to investigate public servants suspected of leaking information about the appointment of Ms. Buroto. The investigation stems from a complaint dated 24 November 2020, launched in terms of Section 4, subsection 1 of the Executive Members Ethics Act by the Chief Whip of the Economic Freedom Fighters, Mr. Nyiko Floyd Shivambu. Having analyzed the complaint, the PPSA decided to focus the investigation on the following two issues: whether the minister acted in violation of the Executive Code of Ethics as contemplated in EMEA when he appointed Ms. Buroto as Chief of Staff for the Ministry of Public Enterprises, and whether the Department of Public Enterprises did not follow proper procurement process in the appointment of Abacus Financial Crime Advisory to investigate public servants suspected of leaking information about the appointment of Ms. Buroto, and if so, whether this amounted to maladministration and improper conduct as contemplated in both the Constitution and the Public Protector Act. On the basis of evidence uncovered during the investigation and the relevant regulatory framework, the Public Protector South Africa found that the minister did not act in violation with the Executive Code of Ethics when he appointed Ms. Buroto as the Chief of Staff. The minister appointed Ms. Buroto to the position in question in line with Regulation 66 subsection 2 and subject to Regulation 67 subsection 5 of the Public Service Regulations, whereby he sought approval in line with these public service regulations from the former Minister of Public Service of the Public Service Administration, Minister Senzo Mkhulu, by way of a deviation for Ms. Buroto's lack of formal qualification for the post of Chief of Staff that is linked to his term of office. The conduct of the minister was therefore not inconsistent with Section 96, subsection 2b of the Constitution. Consequently, his conduct was not in breach of Clause 2.1d and 2.3c, d, and f of the Executive Ethics Code. In addition, the PPSA found that the department did not irregularly appoint Abacus to investigate public servants suspected of leaking information about the appointment of Ms. Buroto. According to the information and evidence submitted during the course of the investigation, the appointment of Abacus was in compliance with the Constitution, preferential procurement policy, and broad-based black economic empowerment legislative frameworks. Evidence submitted noted compliance with the department's supply chain management policy in that a request for quotation sourced from the department's panel of forensic investigators was sought and evaluated. The evaluation on price and triple BEE was done, and as a result indicated Abacus ranked number 1. Accordingly, the department's conduct in this instance did not amount to improper conduct as contemplated in the Constitution and maladministration in line with the Public Protector Act. I move forward to the matter of the Democracy in Action versus the Directorate for Priority Crimes Investigation, report number 19 of 2022-2023. The PPSA investigated allegations that when the DPCI conducted a search and seizure and or confiscated items belonging to a member of the public, Ms. Zamaswazi Majozi and her family in August 2021 under inquiry of the DPCI, the members of the DPCI abused or unjustifiably exercised their power and conducted themselves improperly. A complaint lodged on 14 September 2021 by the Democracy in Action, a civil society organization, prompted the investigation. In the complaint, the Democracy in Action alleged that Ms. Majozi, who is active on Twitter platform under the name, I quote, "Spitty Evaluator," I unquote, was arrested by the DPCI on the 28th of August 2021 on suspicion that she incited public violence during the public unrest that took place in KwaZulu-Natal and Gauteng in July during the year 2021. According to the Democracy in Action, at the time of lodging the complaint, it had been 3 weeks and Ms. Majozi's devices had not been returned to her, and there was no indication as to when she would get them back. As a result, Ms. Majozi's family was negatively affected in that she and her family were not able to communicate with their clients, and as well as it affected their children's schooling. In the Democracy in Action's view, this was a violation of the family's human rights. During a consultation with the PPSA on the 6th of October 2021, Ms. Majozi's husband submitted that the devices included cell phones, laptops, tablets, a router, and a memory stick. Having analyzed the complaint, the PPSA decided to launch a preliminary investigation and to focus it on whether the members of the DPCI followed due process and complied with the applicable regulatory framework, including any orders of the court while effecting search and seizure arrest and detention of Ms. Majozi, and if not, whether such conduct was improper as envisaged in the Constitution and maladministration in terms of the Public Protector Act. The PPSA then learned that the matter was a subject of criminal and civil proceedings and that Ms. Majozi was legally represented. On the basis of the above, the PPSA is disinclined to engage on a parallel investigation with the matter pending before a court of law, particularly a criminal matter, to avoid misalignment of findings between the office and the courts and the potential of conflicting decisions or being seen as defeating the ends of justice. Following, in the matter of Dirks versus President of the Republic of South Africa, the PPSA investigated allegations that the President, Cyril Ramaphosa, violated the Executive Code of Ethics in that he failed to inform or provide evidence to all relevant investigative authorities regarding the alleged misuse of state funds for party political activities in order for them to investigate. The investigation follows a complaint lodged on the 26th of January 2022 and 7 February 2022 by Mr. Marvin Dirks, MP. The complaint is based on a leaked audio recording widely circulated in December 2029, wherein the President is allegedly heard saying that he was aware of how public funds were used for certain political campaigns within the African National Congress political party. Having analyzed Mr. Dirks' complaint, the PPSA decided to focus the investigation on whether the President violated the code in that he failed to inform all relevant investigative authorities that he had knowledge and evidence regarding the misuse of public funds for the 54th National Conference of the ANC, which was held in 2017. It has been found that the allegation is unsubstantiated. Evidence obtained indicates that prior to the President making these utterances, it was widely reported, even in the Zondo Commission, which was public, on the misuse of public funds by the ruling party for party political gains. There is no evidence upon which the PPSA can find that the President contravened any provisions of the code. In the circumstances, the Public Protector South Africa is satisfied that the utterances of the President in the audio was not in violation with the code. Accordingly, the investigation is closed. However, I wish to reflect on the response of the complainant, Mr. Dirks, to the discretionary notice. He is alleging that the PPSA is shielding the President from scrutiny. This allegation is unfounded. He says the President's leaked remarks arose as he was being asked about the funders of the CR17 campaign. It is crucial for us to emphasize that Mr. Dirks' complaint, as you will see in the report, was never about the CR17. In any event, we could not reinvestigate the CR17. Be that as it may, we agree with the Constitutional Court's confirmation in the Amabungane matter earlier on the Executive Code of Ethics regarding its unconstitutionality insofar as it does not require members of the executive who are subject to the code to disclose donations made to the internal party political election campaign. We look forward to the review and amendment to the code within the 12 months as set by the court. I now move over to the formal reports where we have found that the allegations have been substantiated. In the matter of Luwele versus Limpopo Department of Cooperative Governance, Human Settlements and Traditional Affairs, the PPSA investigated allegations of maladministration relating to the undue delay by the Limpopo Department of Cooperative Governance, Human Settlements and Traditional Affairs in building an RDP house for Ms. Anna Malichachi Luwele. The investigation followed a complaint lodged on the 25th of February 2020 by Ms. Luwele. She alleged that she applied for the house in 2008 and the application was approved in 2012, but to date the house has not been built for her. Her grandson, Mr. Bene Luele, allegedly consulted the Fetahomu Dubatselomko municipality in 2019 and was informed that the municipality's housing subsidies system showed that the house was built during the 2012-2013 financial year. Mr. Luele allegedly visited the municipality in February 2020 after being advised to do so. He was allegedly informed that the HSS showed the house was built and that a contractor was paid in 2012. Officials allegedly informed him they could not allocate a house twice to the same person and suggested that his grandmother applies again through another person. The investigation focused on whether the department unduly delayed or failed to build Ms. Luele's RDP house despite having approved her application in 2012, and whether the service provider was paid, and if so, whether such conduct amounts to improper conduct as envisaged in the Constitution and maladministration in terms of the Public Protector Act. It was found that indeed the department unduly delayed and failed to build Ms. Luele's RDP house despite having approved the application in 2012, and that the service provider was paid in a house that was never built. Following inquiries by the Public Protector, the HOD appointed a new service provider who started to build the house for Ms. Luele. To remedy the improper conduct, maladministration, and prejudice, the investigation uncovered the HOD must, amongst other things, furnish Ms. Luele with a written apology for the prejudice suffered as a result of the failure or delay by the department to build her RDP house, since it was approved in 2012 as contemplated in the Batupili principles, within 30 days of the issuing of this report. The HOD must further conduct an internal audit in respect of all RDP housing projects to establish whether there are other houses that were not built but the service providers were paid, and provide a detailed plan on how to deal with houses which were approved but not built, and that this must happen within 60 days of the issuing of this report. And further, that the Public Protector South Africa will closely be monitoring the construction of the RDP house of Ms. Luele, and that they provide the Public Protector with a report on a monthly basis. I wish to at this stage move forward to the next investigation, which was the Northern Cape Department of Health. This was an investigation regarding the misuse of PPE funds. The PPSA investigated allegations of improper conduct and maladministration relating to the procurement of goods and awarding of a contract to Micronym 37cc by the Northern Cape Provincial Department of Health to supply the department with personal protective equipment. This was an own initiative investigation based on a Sunday Times newspaper article published on the 30th of August 2020 under the subheadline, I quote, "Northern Cape Premier Zamani Soul could be in hot water after the wife of his advisor, Norman Shushu, and his friend Somandla CBC were revealed to have won COVID tenders," I unquote. The article alleged, amongst other things, that officials awarded tenders worth more than 27 million to Macronym 37, a Kimberley-branded agency owned by Somandla Christopher CBC, who is believed to be a friend to the Premier. It also alleged that Mr. CBC's company was awarded a tender despite being under a process of deregistration by the company's Intellectual Properties Commission for non-compliance due to its failure to submit tax returns since 2017. According to the article, the wife of Mr. Norman Shushu, the special advisor to the Premier of the Northern Cape, was awarded a 30 million rand tender to supply the South African Police Service with 1 million masks. After thorough analysis of the investigation, the PPSA decided to focus the investigation on two issues. Firstly, we investigated whether the Premier of the Northern Cape and the MEC for Health played a part or influenced the department to award a tender for the procurement of PPE to Macronym 37cc, owned by the Premier's alleged friend, Mr. Somandla CBC. If yes, whether the conduct of the Premier and the MEC constitute improper conduct in the Constitution and maladministration as enshrined in the Public Protector Act. Secondly, we investigated whether the procurement of PPE and the awarding of a contract to Macronym by the department was not in accordance with the relevant laws and prescripts relating to procurement of goods and services, and if yes, whether the conduct of the department constitutes improper conduct in terms of Section 182(1) of the Constitution and maladministration in line with the Public Protector Act. The allegations against the Premier and the MEC in relation with Micronym 37cc were not substantiated. However, the investigation revealed that indeed the procurement of the PPE and the awarding of the contract of Micronym by the department was not in accordance with the relevant laws and prescripts regulating the procurement of goods and services. The conduct of the department was regarded as being improper and constituted maladministration. The appropriate remedial action we are taking in this regard is that within 60 days of receipt of this report, the Provincial MEC for Health must take appropriate action in terms of Section 27(1)(a) of the Public Service Act, read with paragraphs 18.1 in Chapter 7 and paragraph 2.7.2 of the Senior Management Services Handbook 2003 against Dr. Tays for his failure to comply with the requirements of Section 38, 39, 40, 41, and 42 of the PFMA and with the policy regulating procurement of goods and services and incurring associated expenditure when the department awarded the contract to Micronym 37cc. In addition, the head of the department must, amongst other things, take appropriate action in terms of Section 38H of the PFMA against any official who contravenes Section 45 of the PFMA and take appropriate action to ensure that all officials involved in the supply chain management unit are properly trained in the provisions of the PFMA, Treasury regulations, the policy, and the National Treasury Supply Chain Management prescripts. Both steps must be actioned within 90 days of receipt of this report. In the matter of Murray versus the Department of Defense, the Public Protector South Africa investigated allegations of maladministration, irregular procurement and expenditure of approximately 35 million on unauthorized medicines from Cuba by the Department of Defense. Originally, an own initiative investigation launched on the 17th of February 2021, a complaint on the same issue was subsequently received on the 19th of February 2021 from Mr. Cyril Jacobus Murray, MP at Democratic Alliance, Shadow Minister of Defense and Military Veterans. According to Mr. Murray, the DoD procured a Cuban COVID-19 treatment, interferon alpha 2B, Heberon, worth in excess of 200 million. However, the National Department of Health allegedly banned the drug from being used to treat the symptoms of COVID-19 virus. He further alleged that the DoD has already paid 35,430,000 doses of the drug and was to make a further payment of 182 million for a consignment which had already been delivered. Moreover, Mr. Murray alleged that the DoD cannot use the drug because it did not make the necessary application to the South African Health Products Regulatory Authority, known as SAPRA, before going into procurement. Furthermore, the DoD allegedly did not capture the procurement on its inventory. The procurement of the drug was allegedly done without due process. Having thoroughly analyzed the complaint, the PPSA decided to focus the investigation on whether the DoD failed to follow a proper procurement process when procuring the drug, and if so, whether such conduct constituted improper conduct in the Constitution and maladministration in the Public Protector Act. The PPSA found that the DoD did not follow a proper procurement process when procuring the drug. The DoD procured the drug from the Cuban government based on a bilateral agreement signed on the 10th of January 2012 concerning defense relationships established between the South African and Cuban governments. In procuring the drug, the DoD senior officials confirmed that they did not comply with any South African legal prescripts regulating the public procurement of goods and services other than relying on the said bilateral agreement. However, the DoD contravened the said bilateral agreement, which they claim to have relied on to procure the drug, because Article 1 thereof clearly states that the bilateral agreement is subject to each country's domestic laws and financial constraints. The drug procured was not registered to treat COVID-19 in South Africa, and the DOD senior officials proceeded to bring it into the country on the 27th of April 2020, prior to them applying for its registration to SAPRA. SAPRA directed the DOD on the 3rd of November 2021 to return the drug to Cuba, failing which the batches will be confiscated and destroyed. The SANDF reported to SAPRA that the unregistered or unauthorized medication in question was returned to Cuba on the 20th of January 2022. The conduct of the DOD in procuring the drug from Cuba constitutes improper conduct as envisaged in the Constitution and maladministration as stipulated in the Public Protector Act. To remedy this maladministration and improper conduct, the President of the Republic of South Africa, as well as the Cabinet Minister for Defense, must take cognizance of the findings of maladministration and improper conduct mentioned in this report, and in line with the authority vested on the President in terms of Section 202, subsection 2 of the Constitution, and in his capacity of the Commander-in-Chief of the SANDF. The Secretary of Defense must take note of these findings and ensure that as the accounting officer contemplated in terms of Section 8A and E of the Defense Act and in line with the powers vested on the accounting officer in terms of Section 38 of the PFMA, issue a directive that any further procurement for DOD is aligned with the requirements of the Constitution and all applicable provisions of the PFMA, the relevant Treasury regulation, and the DOD's SCM policies. The Secretary of Defense must also ensure strict compliance with the provisions of these prescripts and enforce adherence in order to efficiently and effectively manage all the DOD revenue, expenditure, assets, and liabilities. In addition, the Secretary of Defense must, within 60 days from the issuance of this report, initiate an investigation in terms of Section 10 of the Defense Act and take appropriate action in terms of Section 8G of the Defense Act against the DOD officials involved in the irregular procurement of the interferon alpha 2B Haberon drug from Cuba. Further, the Chief of Defense must take cognizance of the findings of maladministration and improper conduct mentioned in this report and further render the necessary assistance to the Secretary of Defense in order to ensure effective implementation and fulfillment of the duties of the Secretary of Defense contemplated in terms of Section 9 of the Defense Act. The Chief of the SANDF must also adhere to all delegated lawful instructions received from the Secretary of Defense in terms of Section 10 of the Defense Act relating to disciplinary or departmental investigations in this matter. I move further to the matter of Zungula and others versus the former Minister of Defense and Military Veterans, Ms. Nosiviwe Mapisa-Nqakula, and another. The PPSA investigated allegations of improper conduct and maladministration relating to the former Minister of Defense and Military Veterans, Ms. Nosiviwe Mapisa-Nqakula's official trip to Zimbabwe in September 2020. The investigation was based on a total of 5 complaints by Mr. Vuyolwethu Zungula, MP of the African Transformation Movement, on the 9th of September 2020. Mr. Hadlo Veli Spies, acting on behalf of AfriForum, on the 10th of September 2020, Mr. Peter Groenewald, MP of the Freedom Front Plus, on 11th September 2020, as well as Mr. Bukang Mtlatlapa on the 14th of September 2020, and Mr. Elias Miller on the 14th of September 2020. All 5 launched the complaints against Ms. Mapisa-Nqakula and the President Cyril Ramaphosa in relation to the former's official travel to Zimbabwe in a South African National Defence Force aircraft during the period of between 8 and 9 September 2020. An African National Congress known as the ANC delegation, led by Party Secretary General Mr. Elias Sikhobelo Mahashule, accompanied Ms. Mapisa-Nqakula on the trip. The complainants allege, amongst other things, that Mapisa-Nqakula undertook an international trip to and from Zimbabwe in a South African Defence Force aircraft with a delegation of the ANC members during the period when the South African as a country was placed on lockdown level 2, which prohibited international commercial flights other than repatriation flights. They allege that Ms. Maphisa Nqakula, traveling to Zimbabwe with the ANC members, violated Section 80, subsection 3 of the Defense Act 2002, which requires consultation between the Minister of Defense and the Minister of Finance prior to the conveying of any person who is not an officer or employee of the state by means of any vehicle, aircraft, or vessel belonging to the Department of Defense. On the basis of a thorough analysis of the complaints, the following two issues were identified to form and focus the investigation. Whether Ms. Maphisa Nqakula ferried the ANC delegation to and from Zimbabwe in an SANDF aircraft in violation of applicable legal prescripts, and if so, whether such conduct was improper and constitutes maladministration as envisaged in the Constitution and the Public Protector Act. Whether the Department of Defense and military veterans suffered financial prejudice as a result of Ms. Maphisa Nqakula's conduct of ferrying the ANC delegation to and from Zimbabwe in a South African National Defense Force aircraft, and if so, whether such conduct was improper and constitutes maladministration and unlawful enrichment or receipt of improper advantage by a person as a result of an act or omission in the public administration as envisaged in the Constitution and the Public Protector Act. On the first issue, the PPSA found that indeed the former Minister of Defense and military veterans, Ms. Maphisa Nqakula, ferried the ANC delegation to and from Harare, Zimbabwe in an SANDF aircraft in violation of applicable legal prescripts. Ms. Maphisa Nqakula departed South Africa together with a total of 6 members of the ANC's delegation on an SANDF aircraft from the Waterkloof Air Force Base on the 8th of September 2020 and returned to South Africa through Waterkloof Air Force Base with the same ANC delegation on the 9th of September 2020. Ms. Maphisa Nqakula neither had the authority nor the permission to ferry the ANC delegation in an SANDF aircraft that was approved to transport herself and her staff to and from Harare, Zimbabwe for an official meeting with her counterpart, as approved by the President Cyril Ramaphosa, as reflected in the submission dated 7 September 2020 submitted by Ms. Maphisa Nqakula. It is found that Ms. Maphisa Nqakula's conduct of ferrying the ANC delegation to and from Harare, Zimbabwe in a SANDF aircraft was in breach of Section 96, subsection 1C of the Constitution, in a sense that state resources were inappropriately used to improperly benefit a political party. Accordingly, Ms. Maphisa Nqakula's conduct constitutes improper conduct as envisaged in the Constitution and maladministration as contemplated in the Public Protector Act. Regarding the second issue, the PPSA found that certainly the department suffered financial prejudice as a result of Ms. Maphisa Nqakula's conduct of ferrying the ANC delegation to and from Zimbabwe in the SANDF aircraft. The state incurred travel financial costs as a result of the trip to and from Harare, Zimbabwe. The department has since calculated the amount due by the ANC using paragraphs 1.8 of the Guide for Executive Members of 2019. The amount is 105,545 rand 46 cents. On the 30th of September 2020, the ANC reimbursed the department the said amount for the cost incurred for their delegation. In view of the above, Ms. Maphisa Nqakula's conduct of ferrying or giving lift to the ANC delegation on the SANDF aircraft constituted an improper advantage and or unlawful enrichment to the ANC as envisaged in the Public Protector Act. To appropriately remedy this improper conduct, maladministration, unlawful enrichment, or receipt of improper advantage, the President must, within 30 days of receipt of this report, give an instruction for the issuance of a directive for compliance with the Ministerial Handbook in terms of Section 85(2) of the Constitution to handle the practice of giving lists to ensure that cabinet members and deputy ministers act within the confines of Section 92, subsection 3A of the Constitution at all times when dealing with state resources. No remedial action is taken against Mapisa Ngakula, as the president had already admonished her and directed that her salary for 3 months be forfeited to the Solidarity Fund. Furthermore, no remedial action is being taken in respect of the recovery of the cost of the trip from the ANC, as the party had already paid the amount determined. We have further concluded 21 reports, which are as follows. I will just paraphrase, because we did say that we will just summarize the 8 reports, and the rest of the reports will be available on the website. There's the report of the Mpumalanga Department of Health, which relates to investigation into allegations of irregular payment of remuneration and failure to register the complainants on the parcel. This report has been closed on the basis that the allegations are unsubstantiated. Heron versus the City of Cape Town, it relates to an investigation into allegations of improper conduct and maladministration against the Immovable Property Adjudication Committee of the City of Cape Town, related to its alleged obstruction of an application submitted on 18 May 2018 by the city's Transport and Urban Development Directorate for the disposal of the Salt River Market site for social housing. This matter is also closed on the basis that it is unsubstantiated. Mowat versus eThekwini Metro Municipality, it relates to an investigation into allegations of improper use of portions of the land belonging to Halkirk Farm and the improper securing of an expropriation order by the eThekwini Municipality. This matter has also been closed. Moyo versus Gauteng Enterprise Propeller, it relates to an investigation into allegations of improper conduct, abuse of power, and maladministration by the officials of the GEP. The former acting chief executive officer, Ms. Leah Manenze, and the GEP Board of Directors. This matter has also been closed on the basis that the complaint could not be substantiated. Anonymous versus National Energy Regulator of South Africa, it relates to an investigation into allegations of various instances of maladministration, abuse of power, and improper conduct by the former chairperson of the National Energy Regulator of South Africa Board Directors, Mr. Jacob Medise, and the former Chief Executive Officer of NERSA, Mr. Christopher Foley. The matter is closed on the basis that the allegations are unsubstantiated. Anonymous versus the Department of Rural Development and Land Reform, it relates to an investigation into allegations of maladministration, improper conduct, corruption, fraud, and irregularities in acquisition, transfer, and utilization of land, livestock, and assets under the Land Reform Act. This matter is also closed on the basis that the allegations could not be substantiated. Mainir versus the Public Investment Corporation, the PIC. This matter involves the former Minister of Finance, Mr.
Coming out of that briefing by the Acting Public Protector, Kolega Skalega, saying that they have completed 29 reports, but only touching on 8 there, including the Shivambu versus Godan and the Dirks president against the president of the
municipality processing procurement is trained. Nebechane versus the Department of Health. This matter relates to an investigation into allegations of undue delay by the National Department of Health to respond and to assist a complainant. The observations, detections, and any further possible medical treatment by the medical team was not properly explained to this complainant, we found, in a language and terminology that the complainant understands, considering his medical condition. It is therefore recommended that the Director General intervene and ensure that the meeting is arranged between the medical team and the complainant, accompanied by his family, to, amongst other things, explain and provide all with a written report as to the outcome of the observations made during the medical observation in a language and terminology that will be comprehensive to all. I thus wish to thank the Public Protector team that worked tirelessly to ensure that we produce quality reports today that will have an impact in the lives of the public. Colleagues, your dedication, due diligence, and passion to serve and keeping Public Protector South Africa alight, even during the most difficult of time, you are appreciated. Members of the executive exercising authority over the departments against which we have taken remedial action are implored to assist PPSA in line with their constitutional imperatives to ensure implementation, as this will assist in addressing the much required governance reforms and curb corruption, thus contributing to the growth of the South African economy. Lastly, to the members of the public, we call upon you to continue with the good work of being watchdogs and ensuring accountability by state organs, thus assisting us in carrying out our mandate to strengthen this constitutional democracy. I thank you.
Thank you, Acting Public Protector. We have distributed a copy of the statement around the room, and copies of the reports will be uploaded on the website immediately. But those of you who are part of our WhatsApp group will also receive them shortly. Now I'm going to open the floor for questions. I'm going to request all of those who will be posing questions to the panel to first introduce themselves, indicate which media house they represent, and then they can then put through their questions. Let me see by a show of hands who would like to go first. Doesn't look like anyone wants to take the first bite at the chair. Either they are cold feet or the statement was clear. So in the absence of any questions to the panel, I will then propose that we adjourn the press conference. Oh, there's a hand here.
Sorry, I'm not from a media house, so I thought I should give them an opportunity first. Okay, good morning everybody. My name is Onalena Taha. I am here on behalf of Gadi Godrich attorneys on the matter of democracy in action and the DPCI of Zamaswazi Majozi. A part of the statement says that due to criminal and civil proceedings being represented, the criminal proceedings have been removed of the roll. Does this give the Public Protector SA leverage to now reinvestigate, or should it be closed completely first, despite the civil proceedings? That's my question.
Okay, I'll hand over to the acting COO to answer the question.
Thank you, as the acting PP indicated earlier on, that the main subject of the investigation on this particular matter related to the actual conduct of the police when they arrested Mr. Majozi in this instance. And that the matter was still being pursued before us. And both Mr. Majozi had actually brought a civil claim against the police for their conduct during this particular arrest. And that was the basis for us not to conduct any further investigation, considering that this matter was already before court. Where we are at this stage is that we have confirmed that all the devices that were seized by the police during that arrest have been returned to Ms. Majosi and her family. And that at this stage we'll then have to reconsider in light of this development whether there is any further involvement by the public protector into this matter or not. So we will have to then reconsider it and then make a determination on whether or not, and the basis on which obviously the matter has been withdrawn before court must first be considered before we can give a final determination on this particular matter. Thank you.
If I may, Chairperson, just qualify. In fact, the matter was not withdrawn. It was struck off the roll. Therefore, it is two definitions. And at this stage, we do not know whether the matter would be placed back on the roll or not. But be as it may, considering the responses that the head of the DPCI had submitted to us, which are detailed in the report, which will be available on our website, we will not be inclined to further investigate this matter.
Thank you, Public Protector and Ms. Gabinde. The ENCA has sent through a question on WhatsApp. They have a camera person in the room, but there is no reporter here. They want to find out how far the investigation into the former police commissioner, Mr. Khomotso Phahlani's complaint about his suspension from SABC. They would like to know they would like to know the status of that particular investigation.
We will have to respond to that just directly to the ENCA on the progress of that investigation.
Okay. Thank you, Mr. David. I don't think there are any more questions from the floor. So on those grounds, I would suggest that we adjourn the press conference. We will be distributing the content as I said earlier. Thank you so much, all of you, for coming through.
Thank you.